The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 998, and it is coming to you on Monday, the 26th day of April, 2021. Quite sadly and most unfortunately, Mr. P.R Campbell Queen's Counsel passed from life to eternity on Monday, the 19th of April, 2021. My family and I are deeply saddened by this loss, and we are heartbroken and overcome with grief. We know that the nation also weeps and mourns with us. We are grateful and we extend our gratitude for the outpouring of love, support, prayers, and expressions of sympathy on the passing of our beloved father, a husband, an uncle, colleague, friend. On this evening's program, we will honor the memory of Mr. P.R Campbell QC, particularly his contribution to nation building through this educational program, and we will re-air the very first presentation of The Law New, which was aired in April 1997. The topic of that program is Succession to Estate on Intestacy. But before we re-air that program, a few preliminaries. I would like to express condolences to all families who have suffered recent bereavements, particularly to the family of Mary Nichols of Rockies, who was a very close and dear family friend of my father's and the Maxman family of Rockies, and also to the Gurley family on the passing of their family member who went by the nickname of Boy. We pray that the Lord will be with you as He has been with my family during our time of bereavement. It is truly prayer that will see us through, particularly as it pertains to what is taking place in our nation with the eruption of the La Soufrière volcano. My thoughts and my prayers are with all of those who have been displaced, those in shelters, those in private homes. My prayers are with this nation as we go through this difficult time. But we know whatever the future brings, our faith is what will see us through. So I was very heartened by the announcement of the National Day of Prayer and Fasting, which took place today. And I would like to encourage all of us as Vincentians, as we see what is going through in our nation with the La Soufrière volcano, with the COVID-19 pandemic, that we would truly reach out to the Lord in prayer for the healing of this nation, that He would be with us, that He would be with the different officials about their duties, that He would be with those who are hurting the most, as all of us are hurting. So I would encourage us at this time to continue, even after today has passed, to continue in periods of prayer, fasting, and repentance. So at this time, we will re-air the very first presentation of The Law and You, which was recorded in the office of P.R Campbell Company by my dear, now departed father, P.R Campbell Queen's Counsel.
Ladies and gentlemen, good evening. When I addressed you last Thursday evening, I promised that I would be starting a new brand series of discussions on legal topics. I would therefore like to welcome you to the very first program in the series The Law and You, during which I and several of my colleagues will be addressing you on various topics of general importance. Before I begin tonight's discussion, however, I need to make a few points by way of a caveat or a caution. The views which will be expressed in the course of the program are views which are meant for general information and should not be used as a substitute for seeking specific advice from your lawyer if you have a specific problem. So that where you have a problem or you require information or legal advice, please do not hesitate to contact your lawyer. And in due course, I will be using the term barrister, the term solicitor, not in tonight's program, but in other programs. And in one of the discussions, I will go through a number of legal terms to explain the similarities and the differences to you. In the past, several lawyers have indeed given public service by way of broadcasts on the radio on legal topics. Some of these are sponsored by various organizations. Those lawyers have to be applauded. My effort and those of my other colleagues in the Educational Forum of the People will be continuing in that tradition of providing as a public service at our own expense information on legal matters. The next caution I wish to administer is this. The law we discuss will be the law as applied in St. Vincent and the Grenadines as of now. St. Vincent law is not always the same as the law in some other countries. For example, in the area of property law, our laws are based on the English common law. St. Lucia's laws are based mainly on the Civil Code of France, particularly the Napoleonic Code. The law in Guyana is heavily influenced by Roman Dutch law. The law in Barbados, while it is based on English common law, as the law in St. Vincent, is not the same always as our law. And the laws of England are not the same as our laws in every respect. So that I will be discussing and my colleagues will be discussing St. Vincent law, the law of St. Vincent and the Grenadines, as it is applicable now. From time to time, we shall have to inform you of the law as it used to be, and we might even go into areas to discuss the law as it could be. But for the purpose of these discussions, we are dealing with our own local laws. The third word of caution is this. Laws change basically in two ways in our system. Firstly, by acts of parliament, when old laws are either repealed or amended, or when new laws appear to be inconsistent with old laws. And laws can also be changed by the decisions of the courts. We may have a particular rule of law today. Then tomorrow we may get a judgment from the Privy Council in London changing that rule of law. And if it is a case in which we are bound to follow that decision, then our law will automatically change. The lawyers may be accustomed to another particular rule. Then along might come a decision of the Eastern Caribbean Court of Appeal changing the law in that respect, and then the rest have to fall in line. So that laws do change. And what we tell you today about a particular branch of the law may not be applicable next month or next year. So that again must be borne in mind, which reinforces the point I made a while ago, that if you have a particular legal problem, please refer it to your own lawyer. The topic I wish to speak to you on tonight is a topic which would fascinate many, many people. It has to do with what happens to your property when you die, particularly when you die without having made a will. So we will be looking at the topic succession to estate on intestacy. One of the features I hope to develop in this series is to break down legal expressions for you, insofar as these expressions are capable of being simplified, so that the average person could intelligently follow the course of the discussion. So tonight's topic, succession to estate on intestacy. Now, these three terms, succession, estate, and intestacy, are terms which many people would understand, but which I believe many more people might not understand. So I wish to explain each term to you in turn. And I've done these homemade graphics, as it were, to assist us as we go along. The word succession, in the context in which I will be using it this evening, answers the question, who gets what? That is, who succeeds to what has been left behind when somebody dies. Broadly speaking, the term beneficiaries in our law now covers that question, who gets what. Now, what is a person's estate for the purposes of the law of succession to property? And you can have a simple definition of estate as all your worldly possessions. When we therefore speak of a person's estate, a person having died and that person's estate being administered, we refer therefore to all that person's worldly possessions. Now, in this topic, let me emphasize the point that this is a legal discussion. This is not a theological discussion. So when I speak about persons making preparation for death by means of a will, I by no means minimize the importance of people making the proper preparations for their souls. But as this is a legal discussion, I shall leave the theological aspects of it to those better qualified to discuss that. Now, we can use the word property to denote a person's worldly possessions. And in the law, there are two basic distinctions, two basic classes of property: real property and personal property. In French civil law, they use the comparable terms immovables to denote real property, generally speaking, and they use the term movables to denote personal property. I will break that down for you even further. Look at this classification, if you will. Real property consists mainly of lands, and land includes trees, it includes minerals, buildings, and interests in land, which is a legal term covering all the rights which a person might have in a piece of land. So real property means property as we think of it and as we speak of it in the normal vernacular, namely some land or some land with buildings upon it. On the other hand, personal property refers to everything which is not real property. The textbooks draw a third distinction and they give a third category of property: chattels real, which today consists mainly of leaseholds. But it is not important for our discussion for me to go into that aspect of it, except to say that there's a further division of real property into corporeal hereditaments and incorporeal hereditaments, but that is technical jargon which need not concern you now. But examples of what we refer to as personal property would be money, money in a bank account, money in a credit union, money as a hand drawn, a susu hand, whatever the money. Shares in a company and stocks, other financial securities, and physical objects motor cars, tools, clothes, furniture, appliances, anything that isn't real property is classified as personal property. We come to the term intestacy in the topic. Intestacy refers to the situation in which you die intestate. And you say, well, that is roundabout. We are speaking of intestate succession. That doesn't carry us very far. That doesn't help us very much. Well, then the next illustration will. The word testate is applied in cases where a person dies leaving a will, whereas the word intestate refers to the situation in which a person dies without leaving a will. So when you say a person died testate, you meant they left a will behind. And when you say a person died intestate, you mean that they did not leave a will. We will be dealing in this discussion with the case where a person dies intestate, that is, a person dies without having made a will. Perhaps in one of these discussions, I may want to go more thoroughly into the concept of wills, the rules that determine whether a will is valid or not. But basically, a will is a paper writing in which a person makes provision for the disposal of that person's property when that person dies. There are certain legal formalities that have to be observed in the making of a will. It has to be done in a particular way. Not much leeway is allowed. It has to be signed by the person making it, or if the person cannot sign, it can be signed by somebody acting on that person's instructions and according to his directions. It must be witnessed by at least two persons present at the same time in the presence of one another, and who are requested by the testator, that is the person making the will, to sign the will on his or her behalf as witnesses. In St. Vincent and the Grenadines, it is fundamental for you to get the point that we have here what is called freedom of testamentary disposition. That is a big legal phrase, but all it means is that in St. Vincent and the Grenadines, a person is absolutely free to leave his or her property, his or her estate, to whomsoever and to whatsoever that person desires to leave it to. In some other countries, for example in Trinidad, you do not have that full freedom. And in that country, if you make a will, and any one of your close dependents can show that you left them out of the will, and they ought to have been included in the will, then you can challenge that will in court, and you can ask the court to declare that you are entitled to something from the person. Not so in St. Vincent and the Grenadines and in many other countries. In our law here, you are free to do what you want to do with your property by means of the dispositions in your will, by means of how you set it out in your will. So that where a person has a lot of property, perhaps not absolutely important if what you are leaving behind consists of a few items, but particularly if you have land, or if you have extensive property interests or extensive holdings, then you ought to consider making a will, or at least you ought to know the consequences of not having made a will. And let me say, I don't want to let anybody feel that you must rush out and make a will, otherwise something terrible will happen to you. There would be quite legitimate reasons why a person might decide not to bother with making a will. So there's nothing to compel that. But if you're in doubt, you should seek legal advice. And you can also seek the advice of your accountant, or even your insurance agent. These are people who are usually quite knowledgeable in these areas of the law. But basically, you do what you want to do in St. Vincent and the Grenadines with your property, and you leave it to whoever you want to leave it when you are making a will. Having said that, and before I go any further, let me make this other point. You can only leave in your will what is yours. You cannot make provisions in your will to leave something for somebody if that something is not yours. And if the something you are thinking of leaving, perhaps a piece of land, belongs jointly to you and somebody else, you can only leave the share which you had in that property. I say this because sometimes you find a husband and a wife were living together for a long time before they got married. In the course of that time, they might have bought a piece of land, and the title deed may have been placed in the name of just one of them. Then they might get married and they rebuild the house, so that by the time one of the couple, one member of that family dies, the other is left basically with a property in which the one who died owning half share, or some other share, depending on the contribution made. So that where a husband and wife own property jointly, but the title deed, let us say, is in the husband's name alone, he cannot make a will leaving the whole property to somebody other than the wife, because the whole property is not his. The title deed may be in his name alone, but the title deed being in the name of one person does not necessarily mean that that piece of property belongs to that person alone. And there are procedures by which you can go to the court and have the court determine the ownership or the respective shares in a particular piece of property if it is disputed, but that will be for another discussion. So basically what I'm saying is that you are free to leave what is yours by a validly made will in St. Vincent and the Grenadines to whoever you want. But what happens if you do not make a will? That is what we are discussing tonight. And if time does not permit us to get through the whole topic, I will then continue this discussion on next Friday night's program. And I'm sure you'll find it of interest. Okay. So, just to recap, testate succession if you leave a will, intestate succession if you do not leave a will. Now, if you die without leaving a will, or, heaven forbid, you leave a will and the will turns out not to have been validly made, and therefore the law says, look, this is not a proper will. Let us say you die without leaving a will. The law has clear rules as to how your estate should be administered and how it should be apportioned, who gets what. This is what the law provides. If you leave a spouse and children, the law provides that the spouse gets 1/3 of your property, of your estate, and your children have to share up 2/3 between themselves. That is, if you die with a wife or a husband, and you're not divorced, a wife and a husband, and this refers to a lawfully contracted marriage, not a common law union. It doesn't matter how many years you've been living together with somebody. If you did not go through a ceremony of marriage according to the law, then that person is not your spouse for the purposes of intestate succession. That law only regards lawful spouses. So, your spouse gets 1/3, your children get 2/3 between them. Now, suppose there is only one child. Suppose you die leaving a wife and one child. Well, the wife gets the same 1/3, but that one child gets the remaining 2/3. If the child is under 18, then some person or persons has or have to hold that property in trust for the minors. But assuming the children are over 18, they can hold the property in their own right. It used to be 21, but the law has been changed to reduce that age to 18 as the age of majority nowadays. Okay, now, what happens if you leave a spouse, that is, you leave a husband or wife, you die without making a will, you leave a husband or a wife, and you have no children? All you have is a husband and wife and other relatives. Well, the law says that husband or wife gets a half of your estate, and your relatives get the other half. But not all your relatives. I will go on to show you right away which of your relatives can look forward to inheriting from you. And this is whether they are in Trinidad, Guyana, Canada, England, Holland, wherever they are, as long as they are alive and they are known to be alive or not known to be dead. Okay, now, what happens if you die and you have no spouse, or your spouse has died before you, and all you have are children? Well then, your children get the whole of your estate to divide among themselves. If there is one child, that child gets everything. 2 children, they share it half-half. 3 children, they share it a third, a third, a third. 4 children, each gets a quarter. 5 children, each gets 1/5, and so forth and so forth. Now, an important development was made here in the law in 1980 by the passing of the Status of Children Act, and Mr. Arthur Williams, who was Attorney General at the time, must be given credit for that act, as well as the Protection of Employment Act. The Status of Children Act practically equalized the status of all children, whether born in wedlock or born out of wedlock. Before that, you know, there was a great distinction between lawful children and bastard children, legitimate children and illegitimate children, children born in wedlock, children born out of wedlock. For the purposes of the succession to property and for other purposes, all children since 1980 now rank equally. So they can succeed to property, inside children and outside children. So if you leave a spouse and 2 inside children and 10 outside children, then the law regards you as having left a spouse and 12 children. And all of your children would have an equal entitlement to what you have left. Now, the law also provides for this situation. That is, you have left no spouse, no children. Then the law says your parents are your beneficiaries in that case. That is, if you have no spouse and no children. Your parents are your lawful beneficiaries. What if you only have one parent? That parent is entitled to your entire estate. And I should say your entire net estate, because from your estate, all of your debts have to be paid, and all of your funeral expenses, and all of the expenses of administering the estate. But for in another discussion, I will discuss with you the procedures and the terminology, application for probate, taking out letters of administration. Some people like to say administrating for the land. Who is an executor? Who is an executrix? Who is an administrator? Who is an administratrix? But to get back to the way the law provides for the disposal of your estate when you die without making a will. We said before, if you left no spouse behind, no children, then your parents. Or if it's just one parent, that one parent gets all. What happens now if you have no spouse who survives you, no children, no parents? The law says your brothers and sisters of the whole blood in equal shares. That is the first category of entitlement. So, brothers and sisters of the whole blood means your full brothers and sisters. That is your brothers and sisters by mother and father. They will get what you have left behind in equal shares. Whether they are in St. Vincent, whether they looked after you, whether you and them were on good terms or not, it doesn't matter. Once they are identified as your full brother or your full sisters, then they will share in your net estate if you die without making a will. Now, suppose you die, no spouse, no children, no parents, no full brothers and sisters. The law goes secondly to your half-brothers and half-sisters. And if there are more than one, they take in equal shares. If only one, that one takes the whole of your estate. Now, you have none of the above. No half-brothers, no half-sisters. Who is next in line? Well, the people next in line are your grandparents. If you have one grandparent alive who survives you, and none of the other categories alive, when you die, that one grandparent will be entitled to your estate if you die without making a will. Of course, as I said before, you are free to make a will at any time, and you can make a new will every Monday morning. What is valid is the last one you make. Now, suppose you have none of the above. Who is next in line as the fourth category? Your uncles and aunts. That is of the whole blood. That is your uncles and aunts who are brothers and sisters of your mother and father as full brothers and sisters. If there are no such persons, the next category would be your uncles and aunts of the half-blood. That is, those related to your mother and father as half-brothers and half-sisters. And what if you have none of these? Well, the law says in that case, it goes to the crown, the government. But let me hasten to add that the law also provides that for all of the categories except that of grandparents, if there is a child of a member of a class, and that member of the class died before you, then before it is given to the government, the law will look at the children of members of the classes who died before you died. So, ladies and gentlemen, in a nutshell and very briefly, in as much as it is not possible to simplify these matters more than a certain limited extent, I hope I have indicated to you the provisions the law makes for the disposition of your property if you die without a will. And it is really up to the individual to decide from case to case whether he or she need make a will or whether he or she can get by without that. That brings me to the end of this evening's discussion. I will return to the airwaves next Friday night, God willing, at 8:20 for another program in the series, The Law and You. I have not decided yet what topic I will discuss, but in as much as there are other aspects of this very fascinating topic yet to be covered, perhaps I ought to take that as my very next discussion with you and go into the principles governing the making of a will and some of the other legal interesting niceties concerning that area. For the moment, it's good night on behalf of the Educational Forum of the People. I hope you have found this talk of some interest, and as time goes by, we shall get into other very fascinating areas of this very fascinating subject, the law.
Mr. P.R Campbell, Queen's Counsel, will surely be missed. Ladies and gentlemen, brothers and sisters, boys and girls, this was program number 998 of The Law and You. I wish you a pleasant week ahead, and may the good Lord continue to bless and comfort us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer P.R Campbell QC and brought to you on SVG-TV as a public service.